You heard some of the more deranged things that Donald Trump said on the campaign trail about kids going off to school and the school changes the gender of the kid, at school that day. Parents don't, just wild claims. He has also more directly, let's just play some of what he said to get your response.
I will revoke Joe Biden's cruel policies on so-called gender-affirming care. I will sign a new executive order instructing every federal agency to cease all programs that promote the concept of sex and gender transition at any age. I will then ask Congress to permanently stop federal taxpayer dollars from being used to promote or pay for these procedures.
Is this case that you are going to argue before the U.S. Supreme Court involving Tennessee relevant to what President-elect Trump says he wants to do there?
Yeah, he obviously says a lot of things, and it's causing people a lot of panic for good reason. And it is relevant. And here's why. Because Tennessee's arguments about why the law that they passed doesn't classify or discriminate based on sex is not limited to a state law, and it's not limited to a law that is banning this care for minors. So if Tennessee is successful, if the Supreme Court in essence sides with the government of Tennessee, I think that will open the door to the types of federal bans on this care, not only for minors, but for adults too.
For adults too, you think?
I do. And I think that's one of the things we should be really concerned about. We're hearing a lot about young people can't consent to this care, but it is their parents consenting to this care. And at the end of the day, we have adults who live as transgender people like myself, who have families, who are part of communities, who are part of this society. And if the incoming administration bans our healthcare, that is essentially excising us from this country.
All right, guys, so we got to talk about a landmark Supreme Court hearing involving a case in which the ACLU is challenging Tennessee's ban on so-called gender-affirming care for minors. Now, this case specifically involves a ban that would not allow children to get access to hormone treatments like puberty blockers and things like that, okay, in order to transition. And they're essentially arguing to the court that this is a violation of the Equal Protection Clause of the Constitution, that this constitutes sex-based, gender-based discrimination, okay? This is their argument that they are presenting to the court, okay? And I want to talk about some of the oral arguments and how some of the judges responded to these arguments. But first, I want to play a clip of this woke lawyer explaining what they're going to argue to the court before we hear how the court dismantled this lawyer's arguments. So let's roll the clip.
And the lawyer who's going to argue this high-profile case before the U.S. Supreme Court, Chase Strangio. Chase, thanks so much for being here. Really appreciate it. So the case comes at a time when 26 states have passed laws restricting healthcare treatments for transgender youth, according to a CNN analysis of data from the nonprofit think tank Movement Advancement Project. So how do you plan to argue before the U.S. Supreme Court in a case that could have wide-ranging implications beyond the state of Tennessee?
Well, thank you for having me, Jake. And obviously, this is a critical inflection point for transgender people across the country. We're coming off of an election season where transgender people played an outside role in people's consciousness in terms of the way in which we were situated as a threat to others. And when we look at the map of states that ban this type of evidence-based healthcare, we went from 0 states that had these bans in 2020 to now more than half the country. So before the court tomorrow, the question is really a simple one as I see it. This is a law that bans medical treatment only when it is prescribed inconsistent with an individual's sex. Our argument is that treats people differently because of their sex, and therefore the court has to treat it like all other forms of sex discrimination, and that's why it's unconstitutional.
So attorneys representing the state of Tennessee told the U.S. Supreme Court, quote, if the government's theory holds, men who identify as women could claim constitutionally based access to women's bathrooms, women's locker rooms, and women's sports. Accepting that theory would perversely erode women's rights and jeopardize landmark statutes protecting women's equal access to schools, winners' podiums, and beyond. What's your response to that?
Well, I obviously disagree with that premise that allowing transgender women into women's sports or women's bathroom is a threat to women, but it is also not the question before the court in this case. And in fact, it is a totally independent question about whether a law that bans medical care for transgender adolescents discriminates against people based on sex versus these separate cases that preceded any of these healthcare bans will continue to be litigated in the courts regardless of the outcome here. So that clearly is conflating a bunch of different questions. The question before the court tomorrow is about whether banning medical care, overriding the consent of parents, the recommendations of doctors is a violation of equal protection.
Yeah, so you see, that you heard that. Now, the argument from the woke lawyer here is essentially that, yes, this is sex-based discrimination because Tennessee is banning hormone treatments for children that is not consistent with their biological sex. So, for example, giving a young girl testosterone, okay, yeah, you can't do that, right? Not with the intent of transitioning. Essentially, what the argument is here is that, hey, well, you're discriminating against people based off sex because if a young girl wants testosterone, she should be able to get access to it, and you can't discriminate against her based off just her sex, right? And the other way around when it comes to young males and giving them estrogen, right? Same argument, same logic kind of applies. Because ultimately, you would not deny a natural born boy access to testosterone to help him go through puberty, just like you wouldn't deny, a natural born girl access to estrogen to go through puberty. So you can't do it when it comes to kids that identify as trans, okay? Just because of their biological sex. That is essentially the crux of the woke argument that I believe is extremely flawed because of just common sense, which is that giving testosterone to a boy to help a boy undergo natural puberty is not the same as giving testosterone to a girl to help a girl transition. Now, how did this argument stack up in court? Well, we're going to talk about it because obviously you have conservative judges, you have liberal judges. I think right now it's 6 conservatives on the court, 3 liberals. I mean, I guess maybe you can count John Roberts as a liberal, right? I'm not entirely sure, depending on who you ask. But regardless, the court is heavily stacked in favor of the Republicans in the conservative argument here, okay? And you kind of saw that play out in some of the oral arguments because, of course, the liberals got on board with this. They essentially compared banning gender-affirming care for minors to banning interracial marriages. Yes, this is what big brain affirmative action Supreme Court Judge Ketanji Brown Jackson said during this oral hearing. Take a look.
Being drawn by the statute. That was sort of like the starting point. The question was whether it was discriminatory because it applied to both races and it wasn't, necessarily invidious or whatever. But, as I read the statute here, the case here, the court starts off by saying that Virginia is now one of 16 states which prohibit and punish marriages on the basis of racial classifications. And when you look at the structure of that law, it looks in terms of, you can't do something that is inconsistent with your own characteristics. It's sort of the same thing. So it's interesting to me that we now have this different argument, and I wonder whether Virginia could have gotten away with what they did here by just making a classification argument the way that Tennessee is in this case.
Yeah, so you see that, you heard that, okay? It doesn't stop there. It doesn't stop there. Justice Sonia Sotomayor essentially compared the risk of going through these potentially irreversible treatments, the risks associated with these medical treatments, to taking aspirin.
Cannot eliminate the risk of detransitioners. So it becomes a pure exercise of weighing benefits versus risk. And the question of how many minors have to have their bodies irreparably harmed for unproven benefits is one that is best left.
I'm sorry, Counselor. Every medical treatment has a risk. Even taking aspirin. There is always going to be a percentage of the population under any medical treatment that's going to suffer a harm. So the question in my mind is not, do policymakers decide whether one person's life is more valuable than the millions of others who get relief from this treatment? The question is, can you stop one sex from the other?
And that brings me to the conservative judges, right? Specifically, Samuel Alito, who is extremely based. He took an absolute sledgehammer to this long overused argument from the woke activists that, hey, the benefits of gender affirming care for children outweigh the risk, which is not true. There's no real scientific evidence to back up these claims. And Justice Alito outlined that very succinctly in this oral hearing. Take a look.
A question about the state of medical evidence at the present time. In your petition, you made a sweeping statement, which I will quote. Overwhelming evidence establishes that the appropriate gender-affirming treatment with puberty blockers and hormones directly and substantially improves the physical, psychological well-being of transgender adolescents with gender dysphoria. That was in November 2023. Now, even before then, the Swedish National Board of Health and Welfare wrote the following. They currently assess, quote, that the risks of puberty blockers and gender-affirming treatment are likely to outweigh the expected benefits of these treatments, which is directly contrary to the sweeping statement in your petition. After the filing of your petition, of course, we saw the release of the Cass report in the United Kingdom, which found a complete lack of high-quality evidence showing that the benefits of the treatments in question here outweigh the risks. And so I wonder if you would like to stand by the statement that you made in your petition, or if you think it would now be appropriate to modify that and withdraw the statement that there is overwhelming evidence establishing that these treatments have benefits that greatly outweigh the risks and the dangers.
I, of course, acknowledge, Justice Alito, that there is a lot of debate happening here and abroad about the proper model of delivery of this care and exactly when adolescents should receive it and how to identify the adolescents for whom it would be helpful.
Medical questions that seem to me to be hotly disputed, and that's a bit distressing. One of them has to do with the risk of suicide. Do you maintain that the procedures and medications in question reduce the risk of suicide?
I do, Justice Alito, maintain that the medications in question reduce the risk of depression, anxiety, and suicidality, which are all indicators of potential suicide.
And do you think that's clearly established? Do you think there's reason for disagreement about that?
I do think it is clearly established in the science and in the record. I think, as with all underlying questions of looking at evidence, there can be disagreement. I don't dispute that. But here, and sort of going back to questions about the Cass review, for example, the Cass review only looked at studies up until 2022.
Well, I don't regard the Cass review as necessarily as the Bible or as something that's true in every respect. But on page 195 of the Cass report, it says, there is no evidence that gender affirmative treatments reduce suicide.
What I think that is referring to is there is no evidence in the studies that this treatment reduces completed suicide. And the reason for that is completed suicide, thankfully and admittedly, is rare, and we're talking about a very small population of individuals with studies that don't necessarily have completed suicides within them. However, there are multiple studies, long-term longitudinal studies, that do show that there is a reduction in suicidality, which I think is a positive outcome to this treatment.
And then we have the crux of the argument here from the woke lawyers, which is that, again, this is discrimination based off immutable characteristics, in which Justice Samuel Alito just easily dismantles this idea that somehow this is discrimination based off immutable characteristics, because by definition, when it comes to the nature of being trans, okay, like, the characteristics of being trans are not immutable, because quite literally they can change back and forth, right? Like it can change, like it's fluid, right? Gender is fluid according to the woke activists. So it's not really an immutable characteristic because it changes.
Does the category of does transgender status apply to individuals who are gender fluid?
I think that the distinguishing characteristic is to have a birth sex that does not align with, or a gender that does not align with one's birth sex. So it may include people who have different understandings of their gender identity, but I think it is still the distinguishing characteristic of a birth sex and a gender identity that are incongruent.
Are there individuals who are born male, assigned male at birth, who at one point identify as female, but then later come to identify as male, and likewise for individuals who are assigned female at birth, at some point identify as female, identify as male, but later come to identify as female? Are there not such people?
There are such people. I agree with that, Justice.
So it's not an immutable characteristic, is it?
Well, I think people's understanding of it shifts, but the evidence shows that there is at least a strong underlying basis. And I think the normative reason for that particular consideration is whether or not this is something that someone should or could change, and whether they should have to change it in order to receive constitutional protections. And I think transgender status squarely fits within that.
Yeah, so you see that, you heard that. Okay, so all indications point to the idea that the conservative justices are going to side with the state of Tennessee, okay? And one of the reasons why is because this is a more nuanced case when you talk about medical practices, and the courts generally want to stay out of the business of trying to make medical judgments and just leave that up to the lawmakers, right? I think that's probably going to be the reasoning here, in the sense that they're going to say, hey, you know what? This isn't really sex-based discrimination for the reasons that I outlined earlier in this video, which is just common sense, right? Which is that there are differences, physiological differences between males and females, okay? And those differences mean that their bodies react differently to sex hormones, okay? Testosterone and estrogen. So with that being said, males and females are not similarly situated when it comes to the administration of these hormones. So when you talk about giving adolescent girls estrogen for example, an endocrine disorder, that's not the same as letting young male, right, or young male youths take estrogen to transition, right? They're not the same thing, okay? It's not the same thing. And without that deferential treatment, there is no real discrimination here, okay? And that's essentially probably going to be the rationale behind why this case ultimately is going to side with the state, right? And it's going to open up the door for the states to basically ban this type of gender-affirming care for children. And who knows, maybe the Republicans will go even further and try to ban it at the federal level, which will cause the woke activists to melt down and lose their minds, right? But I think some of the things that were revealed during these oral arguments is interesting and definitely worth noting. Specifically when you talk about this argument that you're hurting kids just because you don't want them to get access to so-called gender-affirming care, okay? Because there's no real evidence that this stuff helps more than it potentially hurts. And this is why you have countries in Europe just flat out banning it, saying, you know what, we're stopping this, like we're not doing this because we don't have any real evidence that this actually really helps kids. Like this is what they actually need when they're going through these issues. So, you know, I mean, that's essentially all they got at this point. All the woke activists really have are emotional arguments that aren't really grounded in any real science or anything like that. It's just them wanting to impose their ideology or medicine, and they're upset that the states, that Republicans are saying, nah, we're not going to have that, right? You can't do that. It seems as if, based off these oral arguments, that the Supreme Court is going to side with the states. But we will see, right? We will see what ends up happening. Let me know what you guys think. Make sure you like, comment, and subscribe. Most importantly, share a Black conservative perspective. Peace.